Okay, it is 5 o'clock straight up, and welcome to week 5, this September 5th. A lot of fives involved here, and that you should be aware that we are near the end of this course, and that I'm going to take time today. I'm going to discuss the things that many of you should have received the feedback for your course project that you completed um, in the lecture. I mean, in the written assignment. So you should be able to see that. And my video is not active, so I've got to see why my. Okay, let me get my camera going. Start my video. Okay, there we go. Okay, now you see me. And so we're going to go ahead and we're going to get started so that we can get on track. And then we're going to conclude by going over the materials that are due this week. So let me go ahead and share my screen with you. Go ahead and share that. Here we go. Okay, and now you see the course homepage. Again, as I constantly remind my students, I put a lot of information on the course homepage, and very important that you follow these. And you'll see your rubric for week 3. That's not the one I want to look at. Week 3, the rough draft. And it says that it's written as a formal contract and includes all relevant parts, i.e. date signature with minor errors. Student has made progress toward including the required clauses. All of the prices and quantities are accurate. And then APA, I didn't really grade for APA in this assignment because I didn't think that it was essential, so I didn't do it in this time. So nobody got hit with that. And so anyway, what I am going to start out by saying is, first of all, that when completing that draft that you did in week 3 that I graded, and all of you have it, one of the most common errors that was that took place is that students did not look at the what that meant when it said the relevant parts. The relevant parts were spelled out in the, I'm going to go back to Module 3. The relevant requirements in the assignment were laid out in detail in 1, parties, dates, definitions, payment provisions, specific description of the toys, terms of the contract, and limitation of liability, signature line, and the mandated alternative dispute clause. Some students didn't know what that was. It's in your reading, and it is covered. Or you could go and you can Google, and it'll tell you what a mandated alternative dispute clause is. And then, of course, your force majeure / act of God clause there. Some of you put these two just like this. You put it 1 and 2. No, that didn't mean that they were to go after the signature line the way it's here. That means that it should have been one of the numbers above here. Like, for example, it might have fit under 8, and then number 1 would have been 8, number 2 would have been 9, and then the signature line would have been 10. Signature line is always the last thing at the bottom. There's nothing after the signature line because it's in the body of the actual contract. Then I encouraged you, and I had mentioned this during the time I had the lecture in week 3, to look at some contracts, look at some sample contracts. You can Google and go on and find sample contracts. And you could see what they look like and lay your contracts out. That is not for you to copy the contract, but for you to see what is generally in a contract and these things. And of all of you who submitted it, I think probably only about 7 or 8 of you actually did do that in addition to these things. You have to remember one thing. You've seen contracts before and you've signed them. That's what yours was supposed to look like, with those kinds of terms and things laid out here. But it's important that you did those things. Now, I did say provide a cover sheet. I didn't deduct anybody points for that, but cover sheet should have been involved as well. Now, when you do your assignment that we're going to talk about next for your rough draft, for your final project in week 5, which is this week by Sunday, you're going to incorporate the things that I commented to you in my comments relating to these issues here, these 10 things, making sure that those are in your contract, plus what I'm going to talk about in just a few minutes. So that should clarify what we were looking for. All right. Again, many of you did not do it that way, and you had. Then I also suggested, though I didn't take points off for, to make your contract look better and easier to flow, is make sure that you did provide captions. And the captions would just basically be on the left-hand side. Maybe you put them in bold print. Maybe you underline them, and then you start it out. Then you number them. Number 1, the name, date, so forth, so on, and all those kind of things. So, all right. So that's what we'll be looking for the final, and that's what my most common comment was. All right. So now let's go back and let's see where we are here. You're doing this week eminent domain. Summarize the eminent domain example from research. Discuss whether or not the taking of property was fair. Argues whether or not that the government should be able to take property. And then, important, 2 to 3 pages, not 1 page, with APA citing in text, full citations, spelling, grammar, and then you should also have a cover sheet as well. That's your written assignment for week 5, week 6, and then your project, your final project. And it tells you, once again, almost the same kind of things that were in week 3. Required clauses integrated into the contract, which I've already told you. The prices and parties are accurate as described in the fact pattern. If you got them right in the week 3, that's all you have to do. Don't worry about the grammar in APA. I'm not really going to be concerned about that when I grade this assignment. So anybody who says they lost APA points on this contract, bring it to my attention. I did not do that. I did not do that. And so our lecture 5 will be placed here as a recording when we finish, or either sometime late tonight or early in the morning, because I have to convert them over into PDF. So now let's take a look at our week 5 announcements. Property, real, personal, and intellectual property will be discussed. Intellectual property is pretty much discussed in your discussion forum, which we're going to talk about in a minute. And then, so prepare for that, chapter 11 of the textbook. And it's important that you look at that because it gives you definitions, it gives you information about a lot of the terms that you're going to run into in the chapter. Complete the activity properties of all shapes, sizes, and ideas. common ownership interest for real property, and flashcards. Okay, so I'm not going to go over flashcards because I've already talked to you about how to use those. Those are for your benefit. Be sure to participate in the discussion assignment. Why buy it when I can get it for free? That deals with the issue of intellectual property. And so we're going to discuss that very briefly. Then your written assignment, eminent domain. I already gone over the requirements for that, but we're going to go over it again in detail in a minute. And your course project, final one. And then I says pay close attention to the rubrics for written assignments. Pay close attention. Again, as I said before, I, in hindsight, have decided that with the contract project that I will not, I repeat, I will not require APA citations, but I do want a cover sheet with it, okay? I want to see the contract. I want it set up in proper form. And again, I've already given you notes to tell you about what that looks like. You've all seen contracts of one shape, form, or fashion or another, and or signed contracts at the age that you guys are. You've had to sign one. Sometimes they're leases. Sometimes they're contracts to purchase a car. They're contracts to purchase items that you have, and so forth and so on. All right. So now let's take a look at my course calendar real quick. All righty. Here we go. And you can see where we are. This is where we are right here. Your reading assignment. Again, as I said before, you click on it, and it tells you the same stuff that I just went over a minute ago. And then your initial post, you click on that, it also just tells you that. Now, notice this. Your live lecture, and then your reply post. Notice this. This is what I always tell students in the course calendar. Make sure that you see this note. See the rubric and module. Rubric and module. Yes, the rubrics are important, but the content in the module maybe elaborate in more detail. So that's why I say rubric and module. Same thing in course project. The same thing, rubric and module. That's the same remark that I had for all of them. That's same thing when you did week 3, rough draft. If you open that up, you see the same thing located in the module and rubric. So it's important. That's why some of you did not go. One student said they saw the rubric, but the rubric gives a short form, short fashion of those elements. But the module breaks it down 1 to 8, and then there's a 1, 2 at the bottom, which really didn't mean, it should have been 1 to 10. But the way it's laid out, that's no indication that it should be outside of the contract. And that's it for the week. Next week will be our final lecture, and we'll deal with that right now. So without any further ado, I'm going to go right into our current module. Again, going into details here. Your written assignment, it tells you the length of it. Locate an example of eminent domain. So you've studied eminent domain. It's in your book. It's part of reading it. And it says what it is. It's the power of to take private property without permission from the owner for public use by a governmental entity, the state, municipal, or sometimes even a private person or corporation. But just compensation must be paid to the individual. That's what eminent domain is in essence. So usually that happens in situations where there's going to be like, let's say you're in a building and they want to put a stadium there, a big stadium, and the stadium is owned by some big organization, and they will offer you fair price for the purchase of that land and tear that down so they can build whatever they want to build on it. But let's say that you don't want to do it, then they can take you to court, and then a judge will decide whether or not you should have to give it up. Now, the key thing is that the last part of the requirement for eminent domain is what we call payment of just compensation. And sometimes people have an emotional attachment to that property and that land. So what they'll do in a situation like that is, because they can't replace emotional, you can't put a dollar amount on it, they'll get as close as they possibly can to attempt to be able to bring that person to what's considered as, quote, just compensation for that. And that's kind of like the way eminent domain. One of the common ways that eminent domain takes place is if a highway is coming through an area. That happened in Chicago when the Dan Ryan was coming through. There were properties that were right where the expressway was built, or freeway as some of you call it, and there were buildings that were moved. I mean the buildings were moved, and I do mean they were literally moved, and they reconfigured the streets. So the streets that would have been coming down where the expressway is, they moved them further to the west, or in some instances to the east, and left the area in the middle for the expressway. And those are the kinds of things, and that's kind of how eminent domain operates. So that's what your written assignment is all about. So after you've found an example of eminent domain, and they're all over the place, and share a summary of what happened, discuss whether you think the property was fair, if so, why, and if not, why it wasn't fair. Should the government be able to take property through the process of eminent domain, why or why not? And you'll discover in your research a number of arguments that will be presented, such as the benefit to the public outweighs the individual's private gain or private right to the property. And then again, under a whole concept called quantum meruit, don't even worry about that, I'm just throwing this Latin, just compensation, making sure that person is, I think I'm right, quantum meruit. It's been a while since I've used it, but the point of the matter is that the individual is compensated adequately for what happens. Make sure that you've done some research, and you're going to use APA formatting, which is both citations in the body and references in the end with a cover page. All right, that's it for that written assignment. And then of course, the written assignment, you know when it's due. It should show in a second here. Click on, there it is, Sunday, September 9th, and they get 30 points. And then there it is under there what you're supposed to do. All right. So let's go back. Then your discussion post deals with, like I said, intellectual property. People are very familiar with this. You should be aware of the fact that now everybody's downloading music, movies, and all kinds of protected works without paying the appropriate fees. What has happened with some of these instances is that the organization or companies or websites that allow it, they actually will pay fees to the person who created the item, so that when you do it, you get it for free. But as you probably should know, many of those you pay a subscription fee to, like Amazon, or either you do Netflix. My wife, she's a big fan, and I, of PureFlix, which is Christian movies, and we have a monthly subscription that we pay to that, and we are able to download movies. And then there are some instances where you're downloading music and you're getting it for free, but be aware of the fact that a lot of those come with ads, and those ads are what pretty much pays for the music and stuff like that. And so the whole issue in a nutshell is, well, people run into major problems is like, for example, when they, for example, buy phony Nikes, phony Jordans, you get people that actually, and I'm sure you've seen this before. I know I have. Pay attention to it next time you go to the theater. There are almost every time you go to the theater, some people sitting near the front. And they're usually sitting in the section where there's no aisle to come across, so that no one gets in their way. And they'll have their cell phones out. What they're doing is they're actually recording the movie that they're watching. A first run new movie comes out, and they're actually then sending those to a central place, and they're processed, and they make them available on pirated websites, as well as they will reduce some of them to DVDs, and people will buy what we call bootleg, which means that the product that they buy, they're not the best of quality, but people do that. And I've seen people do it a whole lot. On the streets also, there are people who sell tapes of CDs that come out, and there'll be bootleg copies. So those kinds of things. But you hear a lot of times about knockoff stuff like Louis Vuitton or some of these other names that I don't know any. I'm not a big, as they say, a fashion person, but you know what I'm talking about when I talk about those. And, you know, discuss the reason for trademarks, patent and copyrights. You discuss that in your discussion post, and you be aware of the fact that, think about it in this fashion, very simply, that you put your hard effort into creating this item, and someone comes along and they create the same item. Well, you, to protect yourself, you will go to, usually the government has the copy and patent office, and you go through the process where a lot of the copyright stuff is, you can do that on your own. But there are specialized attorneys who are intellectual property attorneys who are really good at protecting those items. Let me give you an example of a situation here. This happened some years ago. I had a dentist who came to my law office when I was practicing, and he had this idea that he showed me for a toothbrush that was disposable, and he had a prototype of it developed, and he demonstrated to me how you could open it up in a sealed, you know, package, and that you can push a little thing in there, and the toothpaste would go on the brush, and you would use it to brush your teeth, and then you throw it away, disposable toothbrush. And I said, oh, this is really nice. And so I told him, I said, well, what you need to do, since I am not a patent attorney, because this is not a copyright deal, this is a patent deal, I said, you need to let me work with you, and I will retain a patent lawyer, or you can get one or the other. So he says, well, I'll work with you on it. So then I came back and I told him, you know, what the deal was and what the cost was. And it was pretty pricey. But I explained to him, I said that the key thing is if you follow this process, these specialized lawyers, that's what they do. They actually go through a special process, and they're categorized as patent attorneys. And these attorneys are bonded and licensed and everything. so that they won't appropriate or misappropriate your property when you give it to them to to patent. It's not worth it because they can lose their license, they can be sued, and all kinds of things. So anyway, this dentist, when he came back and I showed him that, he says, look, I just found this process that someone gave me some information, and he brought me this package, and I looked at it. It was basically where you could self-patent, and this company would take care of it for you. Well, I warned him, and I told him, I said that if you do that, I says you might have some problems. And I says, and one of the problems you might have is that they might take it and they might sell it to somebody else. So he said, but look at how much I spend. Well, it was a fraction of the cost. I think it was like $600 or something like that. The patent deal was going to cost him several thousands of dollars. But the point of the matter is that he would get full protection for his item. Well, anyway, what he decided to do was he decided he's going to go and take the shortcut way. And how many of you should recognize and know that taking things the shortcut way can result in some problems for you down the road? So here's what he did. He went against my advice, went with that company, and he submitted it to them. So sometime, or maybe about a year later, or something like that, he came back to my office, and he puts out on my desk. He says, "Look at this little catalog. There's a company, and I'm not saying this was the company, but anyway, a company called Wright, no relation to me, and they put out these magazines, these catalogs, kind of like Fingerhut or some of these other companies. And in here, in this particular Wright thing, what they do is they show things that are like this, items that people have available and for sale and listed in there. And he had circled on this one page and highlighted. He said, "Look at this." I said, "Yeah." He says, I said, "Oh, wow, so you did end up getting it protected." He says, "No, I'm not getting any money for this. That's somebody else. They stole my idea." So I said to him, I said, "Did you contact them?" And he says, "Yes, I contacted them." He said that they are not responsible. They just publish it. So anyway, he said he did some further checking. And guess what happened? And you can probably figure it out. The company that he had gone with had actually sold it to someone else, made money, changed the name of their company, and then started doing this again all over. And they were a corporation, and so he couldn't get anything from them. So he was out of luck, because what happened is that the person who put it in that magazine had actually gone through the steps of patenting the item and spending the money. So he could have been a millionaire or multimillionaire, because as you probably know now, it's a common thing. They have these disposable. You have them in a lot of hotels, and then I'm sure that each of you have at some point run across it. Well, my guy, early on, this was in the 80s when he brought this idea, and he would have been a wealthy man now. I think he's passed away since that time, because he was an elderly dentist at that time. But anyway, my bottom line point is that's one of those stories that I tell you. I used to work for a big law firm that represented McDonald's. And McDonald's used to have, a lot of copyright infringements. And if you saw the movie Coming to America with Eddie Murphy in it, John Amos played the father who owned this restaurant called McDougal's. And they had a sandwich called the Big Mick,
or something like that. And so anyway, and he also had in there, if you saw the movie, he had a manual that he had somehow got his hands on of McDonald's secrets and techniques. And so it was illegal for him to have those. But basically, what he was doing was copying the company, and he was violating their copyright and trademark infringement and so forth and so on. Have you ever noticed that when you see items like McDonald's or something like that, you'll see in the corner a little circle with an R for registered, or C for copyright, or you'll see some form that lets you know that means it's registered. Well, we as the lawyers were constantly notifying individuals through letters, first to cease and desist from using it, changing their names, and so forth and so on. And it could be as simple as, and what they were doing were they didn't have the golden arches, they had the golden arc. And some of you should know this. Did you not know that the color of the golden arches at McDonald's is actually owned by McDonald's? There are T-shirts that have it on there, but they actually are paid for that. And so anyway, you're paid just compensation for your creative item or product. And so you create problems for yourself when you buy it and you deprive them of the just compensation that they're entitled to for the creativity that they had in bringing these items. And you've seen that before all the time. But pay attention when you get Coke, for example, the term Coke. Did you not know the term Xerox, Xerox, with the circle? They ended up running into problems down the road because of the fact that what everybody started doing, no matter what kind of copier, they said, give me a Xerox copy of it. And they allowed their name to become diluted, and the protection was weakened. I don't know if they ever fixed it further down the road. But the point of the matter is that you can also, by negligence, allow it. And then you have to renew these patents and copyrights after so long. Otherwise, you open them up for people to take them and go over them. So anyway, that's a little bit about that. So now, and it's very interested. Intellectual property is very interesting in itself. And again, I know attorneys, that's all they do. They're what they call intellectual property attorneys. When I was representing entertainers and songwriters, I used to do copyrights for them. There's a thing called the poor man's copyright, where people would try to, what they would do is they would put their songs or pictures or whatever in a envelope and send it to themselves by certified mail, and then they would keep it closed, you know. So, but it doesn't work very well. You also recall that there are many songs now out where you see, for example, Bruno Mars was sued for, I think it was Uptown Funk or one of his top songs, because I think it was either by the Jackson estate, Michael Jackson, or anyway, somebody, because of the similarities. But they allow, the law does allow what we call a fair use portion. I listened to this one song. It's a gospel song, and it starts out with the Three's Company, you know, on it, but they're only using a small portion of it. But you recognize then they go into their own creative music. The bottom line is that those items are copywritten and protected that way. And the best possible way is to follow the proper procedures, pay the money, and get the U.S. Copyright and Patent Office to register and protect your item. So that's all I'm going to say on that. Course project, final project due. And this is what I want to spend the rest of my time here. We
got about 25 minutes, but as much as I need here. It starts out with, it's time to sadly close your deal with Mr. Barker. You've done your negotiating. And by the way, while I'm on this, I did say this in some of your comments in your draft. Do not put in there that you're negotiating part of it. What you are doing here is that you're going to produce a document, and I talked about the four corners rule early on in this course. You're going to produce a document that's a contract called, but it's really a memo of understanding. That's basically what it boils down to. So that the terms and conditions of your understanding are written with the form process that we've talked about with week 3, and then also taking a look at some contracts that you've seen, or either you could go on and find some on Google, on the internet, to make sure. One student did use a bill of sale, and I said that's not the same. There's a totally different idea behind the bill of sale. It's kind of, but it doesn't satisfy the requirement for what we're trying to accomplish in this course. And so you want to be aware, thinking about the fact that you learned about the statute of frauds, that in order for a contract to be enforceable, it must be in writing. Don't include that stuff in here, because that's knowledge that you now have. So this deal does not involve L. It involves what letter. Can you tell me, type in if you know what letter of my legs, which you should be familiar with by now, what letter applies in this contract that we did in week 3 and that we're doing in week 5? What letter? Do you know the letter? Type in the chat box and I'll see it. What's the letter? What kind of a contract? Do you recall? You should have that there. You should have that right there in front of you, or you should have it close by on your computer, someplace where you can see it, because I sent you each details on that. What letter? Okay. M for marriage. Y is for contracts a year or over. That could be an issue. L is for land contracts. Does this contract involve land? Yes or no? Does this contract? It's toys. So toys, and what's the price? That was given in the fact pattern that you used in your week 3. What's the price? No, I don't think it was $1,000. No, you wrote it. You did it in your assignment. It's in there, and it's in week 3. What's the price that's listed in your fact pattern? Wasn't it like 700, 710? Wasn't that it? Well, it was. So anyway, the truth of the matter is that, give me a second here. Go back. Let's look at it. Let's look at it, and then we'll come back. Okay. All right. Last week, negotiations between you and Mr. Barker are done. Okay. So that was the course project that you did in week 2. So then you're going to list the payment amount. So let's go to week 2 and let's see what the payment amount was. And you're right. You're right. It is about toys. It's about a toy transaction. So let's go back to week 2. Here we go. Now, to examine the toys up to a standard, you have to sell them for $750. So basically, what you end up doing, it says, so anyway, you end up with 700 to 710. Though that's where we got that from. And you put that actually in the little grid that when you did the little worksheet. So this is what you're working on to use. You don't see, they're all incorporated. Remember what happened? I told you, starting in week 2, you were building the contract. Week 3, you're giving me the draft of that. So then, and now in week 5, back to week 5, you're taking those things that you used in week 2 and in week 3 rather, and you are now using that. So the deal is that I asked you what kind of contract, what does this involve? And so I said it's not marriage for M, it's not Y for 1 year, which, I mean, that's an argument. But here's the main thing. Is it a land contract? No, you said no. You said it's toys, which is toys is considered as a good. So what is it in the statute of frauds that require this to be in writing? The sale of blank, blank, blank. What is it? And we've covered this earlier in the quarter. You got it, or you're not sure? You don't recall? Because you should be putting this all together. It's only been a few weeks since we did this. Okay, I'm going to keep moving. It's goods over $500. So is 700 to 710 over 500? For sure. So that's why the contract needs to be in writing. And so then the other, just for the sake, is surety contracts. You have executor contracts, E, which is before you get to G. So anyway, the point of the matter is that now you're at the point that you're producing a document that must be in writing to be enforceable. You don't have to put this in there, but you need to, this is what you need to be understanding in your own mind. See, the whole process of learning about business law is learning why something is taking place, and that's what I've been giving you all the way down the road. Why consideration? What's consideration? When you have the meetings of the minds, you have a contract. So here's what you have here. You have now reduced your negotiations to terms that you've agreed upon. Those should have been laid out in week 3. So now, for this final part of the contract, you're going to review the feedback that I gave you and incorporate them into your final draft. I said that in my remarks and feedback. Now, if you don't understand that, do not email me. Do not text me. You probably want to call me and we talk about it. But you should have it because I've laid it out, even though today I'm doing it again. This lecture will help you to do well with that.
Be sure to check all the elements. That's why I said go back and look at what's in Module 3 and proofread your final document for proper grammar and mechanics. 3, you want to be certain that you covered all the requirements. Again, back to the same thing, so that you can collect your money, or I like this one, or maybe just an A. Well, you're not getting any money from me. You hopefully get an A, which several of you did get in week 3. But the point of the matter is then you're going to submit, and don't, like I said, it's not, don't overthink it. It's really basic. It's so easy, and some of you are making it, you know. And then I'm going to tell you what I suspect based on some of the submissions I saw, especially the ones that were submitted late. You didn't follow the steps. Waste makes haste. Haste makes waste. Haste makes waste. Take your time, do this right, listen to what I'm saying in this lecture, and apply that to your final document so that you can maximize this important course project final grade for this assignment. And so I've given you everything that I could give you. I've repeated the feedback that many of you have. And even those of you who got a or 30 points out of week 3, go back and double check. You know, do like you did. They said you're checking your list and checking it twice, like Santa, trying to find out who's naughty or nice. Checking your processes in week 3 to make sure that I didn't miss anything in there, because I might pick it up and then you'll say, oh, you didn't tell me that in week 3. Well, I'm telling you to make sure that you double check that as well. Notice course project final is basically the same thing, but what it is that when we do contracts, and this is how we did as lawyers, we did what we call drafts, and we would look at it, and then we go back and we fix some things in it. We fine tune it. That's one of the things that I said in some of your comments. Fine tune it so that it's clean. But remember what I said to many of you. Look at some sample contracts. Contracts are all over the place. And, you know, sample contracts. Just Google sample contracts. Go look and see what you can find. Again, you probably have some sample contracts laying around at your house or where you work at, those kind of things. There are clauses in there, like the force majeure and the mandated clause. And there's also clear things such as, going back to week 3 again, as I conclude here. Here we go. Making sure that you clearly have the parties. The parties consist of the items that are said after this. Then says that you can make these up. It's okay. The date, this is the date that the contract is being entered into. Definition and interpretations. Now, listen to this. I saw some of you with this. If there are any defined terms, this section should provide definitions. And you need to have that in there. And there's some terms in there that you have to define. Look at some contracts and you'll see it. The payment provisions, the exact price for the goods or services, and the terms that you operate. Remember, you want cash and not a check or credit card for this contract, because that was established in week 2. Specific description of the set of toys. And I didn't care, you know, you could use the description that you had. The bottom line is that when I look at it, I know what I'm buying, okay? The term, the length of the contract, and if there are any options to continue the contract. If there aren't, say there are no options to extending the contract. And then
and then should be noted in the contract that this is for a specific instance. And then the limitation of liability puts the amount of liability to either party to the contract. For example, if Mr. Barker inspects the sets of toys and accepts them as is, it means what it says, and he finds a defect of them at a later date, there is no, you're protected, those kind of things. You know, you bought things as is. That means then there's no warranty. Or if you have a warranty, the warranty is for a specified period, and there are manufacturers and limited liability, limited warranties. Those kind of things we're not really expecting you to get into. And then the final thing is the signature line. Provide the signature line and date at the conclusion of the contract for both parties. So it is important that you do that. So and then besides the above list and the standard elements of a contract, and remember how you discover that? Look at some contracts. Look at some. One student asked me, can we utilize other contracts? I says, I got to let you in on a little secret. Us lawyers, most of the time now, we get contracts that have been done, and then we customize them. We borrow some of the parts of it and customize it to our own situation. And that's how it's done. So there's no problem with that. Make it look like a contract. It needs to look like a contract as well. You'll also include these clauses in your formal written contract between Mr. Barker and you. The mandated alternative dispute clause, I could tell you what it is, but I'm not, because it's in your book. It's covered. And also, you can go and you can research it. What does that mean? And then you'll see what it means. They'll provide you with some examples of what it means. Customize that to yours. But don't put it in your contract after the signature line. This is just two items that should be included. Some of you literally took it in week 3 to mean you did 1, 2, 3, 4, 5, 6, 7, 8. And a couple of you actually did this. Your signature line and date, you said the signature line and date is. Well, you don't have to say that. You don't have to say signature lines. All you have to do is say signature, and then John Doe, Mr. Barker, and John Doe is one of you. And so that's what you do. But it wouldn't be after the signature. It would be above the signature. Signature is usually the last thing. In a few places where people had things, I said, don't put signature up there. Put initials so that somebody initial a certain point. I've seen contracts, and you've seen them, where you have every one of these points initialed by both parties next to it. And that's acceptable too as well in there. But you don't have to do that. And then some language relating to the act of God, force majeure clause. By the way, they are not two different clauses. They're the same thing. And what it basically means is something that is out of control, something that happens like a hurricane, a tornado, a fire, or not an arson, but a fire or water damage, or something that makes it impossible to deliver the item. The toys are destroyed by a natural disaster in a situation like that, then that means that the individual is not required to produce substitute items in there, okay? And so most of the time, the key thing is that there are certain things that are beyond our control as human beings. Accidents can happen and things of that nature. So you want to have something to that effect in there, again. So it's not at the end. And these are the things. But once again, go look at some contracts and understand these things. The one thing about this assignment that is really nice is that there's so many extra terms
that go in contracts other than these that are listed, and you'll see that some of you produce those. And I said, okay, that's fine. But I went through and I looked at what you were supposed to provide, and I was looking to see if you met those requirements. The other stuff is cool, but you don't have to. You don't have to do that. I've written contracts for companies like McDonald's. I've written contracts for Motown Records, some other record companies. I've written contracts for entertainers, athletes. I've written real estate contracts that now pretty much are forms now. I've corporate contracts and regular business contracts and those kinds of things. I've done all of those things as a lawyer coming up. But the point of the matter is that what we're requiring you to do here is simply to provide these 10 items in your contract. And if you want to throw some extra stuff in there, that's fine. Because when you look at some of them, like for example, you might say that this is controlled a choice of law, we call it. If you're in Minnesota, and many of you are, you'll say that the laws of Minnesota control the operation of this contract. That's fine. And I'm not saying you say it exactly like that, but you'll see some language like that. That's acceptable, but that's extra. So that's it for the going back to the course project. That's what I did. And so very important that you listen to this whole lecture so you can make sure that you get the essence of it. Don't listen to it for just a keyword. It's not good for you. It's not good. If you were in class, you didn't come to class just to listen to a keyword. If you were physically in the room, no, you came there to get the knowledge of what the instructor is providing to you in addition to the materials that you should have studied and read, some elaboration. And that's what I do. That's what I do. I don't just read it, but I'll give you some examples and things to help you. So that's all I can say about this week. And I am going to give you a, give me a second here. I want to do something. Okay, I'm going to give you a term that is the keyword. It's intellectual property. That's it. Okay, you want to get your points. So use that, but don't go through and say, okay, good, he said that. I don't have to go through and listen to the whole lecture. Or either I only heard part of it. No, listen to the whole lecture, start to finish, because it's to help you. So with that, I'm going to say good afternoon. I'd say good night because I'm used to doing them real late, but I got 2 more lectures after this. So I'm going to end this session and hope that you have been helped and that you will perform well with this week 5. So good night, or good evening, good afternoon to you guys, and see you next week. Okay.